Hi everyone. Today we are going to see lesson 3 of Capital Market and Securities Law, that is your Securities Contract Regulation Act 1956. This lesson talks about your uh, transaction, your regulation on the transaction of securities that has been listed on the stock exchanges. Okay. So this lesson talks about the main objective of this act is to prevent the any malpractice transactions, any undesirable transactions, and all those things. So we have two main regulation and we have two main regulation act and the rules, which is your Securities Contract Regulation Act 1956 and your Securities Contract Regulation Rules 1957. This is the main two important things which we deal in this chapter. Okay, so the main objective of this act itself is to prevent any undesirable transaction in securities. So whenever there's a security that has been listed on the stock exchanges, so and whenever there is a transaction which has been taken place in the securities, this act would apply for them because they have to prevent any undesirable transactions in the securities. So this ensures the transparency and confidentiality. This ensures the more transparent in nature, and it ensures the safety measures. It acts as a safety measure for the transaction in the securities. By regulating it, prevents the undesirable transaction by regulating. So the main objective is two kinds. It is to prevent the undesirable transaction and to regulate the securities dealing therein by providing certain other matters connected therewith. So the bill of is to provide the regulation of securities, regulation of stock exchanges also. So it is not only the securities; it also regulates the stock exchanges by providing various rules and regulations for them, by providing the criteria eligibility, etc. And so regulation of stock exchange as well as the transaction in the securities in the stock exchanges. Okay. So, okay, that is all about your introduction part and a bird's eye view. This the bird's eye view that covers the entire chapter in a few points. That is, we can cover the later part after completing the chapter. Okay, and what are the things which is under the Securities Contract Regulation Act 1956? What are covered? Okay, so your rules, your securities contract regulations, stock exchanges and clearing corporation regulations, holding inquiry rules, appeal. So whenever there is a dispute, we have to appeal to the SAT, Securities Appellate Tribunal, and if you are dissatisfied on the decision made by the SAT, you can go and appeal to the Supreme Court. Okay, and so non-applicability. So next we come to non-applicability. What are on whom or what are the securities the SCRA Act won't apply? Non-applicability. Section 28 talks about your non-applicability for these persons and for these securities. The SCRA Act won't apply. For whom? For the government, for the RBI or any local authority. So the SCRA Act won't apply for them. And any convertible bond, which can be convertible into equity shares, right? So any share warrant or any option that is given to any persons, okay, whether by conversion. So what are they trying to tell is to any convertible bond which is convertible to equity shares, on which the SCR Act won't apply. SCR Act won't apply, and any securities that has been classified by the central government, any class of securities which is specified by the central government, especially specified by the central government. Okay, and your definitions. So mostly in all the act, mostly the definitions are covered in your section 2. In your lesson 1 and lesson 2, we don't have any legalities on any part. So we have general concepts like your AAF, angel funds, QIBs. Like it's a general fund, but it is important to know because it can be asked in your exams. But here onwards, that is from your lesson 3, the more legalities are going to takes place. Though we have to read the concepts with the section numbers. So the section numbers are important. You have to quote in your exams to, to gain an advantage over others. Uh, so from this chapter, you will see more sections. Okay. So section 2 covers your definitions, and here in this act, the section 2 head covers your securities. What do you mean by the term securities? So securities is like shares, bonds, debentures, warrants, convertible bonds, any mutual fund units, any shares, scrap stocks, derivatives also covered, any units, that is your mutual fund units, any securities, it's okay, and the government securities also covered here. And what do you mean by contract? Contract means any purchase or sale of securities, that is on the agreed terms. So whenever there is a contract, whenever there is an offer plus acceptance is your contract, which is this is in the Indian Contract Act 1872. So whenever there is an offer plus acceptance and which is enforceable by law, offer plus acceptance equal to your agreement, but which is enforceable whenever there is a agreement which is enforceable by law is your contract. But here in this act, they are just telling whenever there is a contract which is related to the purchase and sale of securities, that is a contract. And what do you mean by spot delivery contract? Spot delivery means immediate basis, on an immediate basis. So whenever you are buying a securities and the transaction or the dealings, or you are getting the securities in your demat account on an immediate basis, and that's that actual delivery of securities either on the same day, well, that is happening on the same day itself, uh, or the dispatch is being happening on the same day. Okay, and they're also covering any transfer of securities from the depository, where the deposit is. Okay, deposit is your deposit is a place where the securities are being held by your stockbrokers. That is your deposit. Famous depository is NSDL and CDSL. This is the place where your securities are being held. So okay, and what is mean by stock exchange? Stock exchange is a marketplace for the buying and selling of securities. Like so, any stock exchange, any body of individual. This we have seen in your chapter 2. That is your constitute before corporatization and demutualization, and which also covers your after, which is under scheme of corporatization and demutualization. Okay, so recognized means which has been recognized by the uh, central government. So we have certain criteria for the purpose of recognition. Whenever a stock exchange follows these criteria, so the central government may satisfy themselves as a recognized stock exchange. And what do you mean by government securities? Whenever, so this is simple. Whenever it is issued by the government, it is a government securities. And derivatives. Derivatives we have to take a separate video, because the derivatives, most of the questions in the exams are framed from some spot. So in that video we will cover in depth on what is derivative and what other sums can be asked, what is call option, what is put option, what is your futures, what is your margins. All those will be covered in your separate video. And what is commodity derivatives, which can be covered in your separate video. And SAT is a place where you will here they are telling in definition, SAT means any established under this section which is an SAT. But generally SAT is a place, so Secretaries Appellate Tribunal is a place where you will appeal, where you, if you are dissatisfied by the order of SEBI, you will go to SAT. If you are dissatisfied by the order of SAT, you will go to Supreme Court. And member means any recognized by the stock exchange as a member. Okay, so from till now we have seen the basics, the key definitions which are involved in this chapter. So from this the main chapter begins, that is your section 3. That is your section 3, 4 and 5 is important, because this is where the this is where the stock exchange is being recognized by the central government on following certain criteria. Okay. So what are the thing which is required to the stock exchange for the purpose of recognition? So first one is the stock exchange has to make an application for the purpose of recognition. Mainly we have now two recognized stock exchange, main two recognized stock exchange, which is your NSE and BSE, right? So there are also various other stock exchanges also, you are like Metropolitan Stock Exchange, Calcutta Stock Exchange. So if they want to be recognized as a stock exchange, so uh, they have to make an application. So section 3 talks, they have to make an application to the central government or the SEBI. So mainly the central government has given the powers to the SEBI. They have conferred the powers to the SEBI for the purpose of this application, grant, withdrawal, all these things. But mainly we have to make the application to the central government. The central government is conferred their powers to the SEBI. So every application shall contain the accompanied by a copy of the bylaws. Bylaws is the laws which has been created by the stock exchange itself. So their the market opening times, their rules regarding the uh, selection of members on the stock exchange, etc. That is their own bylaws that has been created by the stock exchange, that has to be accompanied, that has to be given whenever you are making an application to be recognized as the stock exchange to the central government. So for the regulation and control of contracts, and also a copy of the rules, any other rules which has been connected with these bylaws, which has to be accompanied by to the uh, bylaws. And what all the things which are covered in the bylaws. This is not an exhaustive, this is an inclusive. Okay. So particular to the governing body of stock exchange, who actually governs the stock exchange. So the stock exchange, its constitution, who are all the members, what are the powers that has been delegated to each members. So that and all we have to accompany with the application. And the powers and duties of the office bearers, the duties of the office members, the admission. So whenever you are admitting any partner, what are the criteria that you are imposing while admitting a partner, like their qualification, like their background, okay, like their membership, and all the rules regarding the suspension, expulsion. Expulsion means you're removing the partner. So and readmission of members on what basis. So this and all we have to give whenever we are providing the application to the central government, and the procedure for registration of partnership as members. This also we have to accompany. Okay, that is all about your application. When you're so first we have to make an application. On the application, we have to accompany certain documents, which is your bylaws and other rules which are connected to the bylaws. And after making your application, the next step that we can have is your either the grant, either the grant or the rejection, either the grant or the rejection. Okay. So central government, after seeing your application, if the central government is satisfied and all those things, the central government may grant the stock exchange as a recognized stock exchange, or it will reject by giving your opportunity of being heard. Okay. And satisfied. So the powers now powers is now given to the SEBI. So the SEBI will satisfy that after making an inquiry, if any that the rules and bylaws that has been accompanied by the application are in conformity, are in are in a good form, or in are ensuring fair dealing and to protect. So it is ensuring the fair dealing, and the rules are even more protecting the investors. There's no a chance of malpractices. So the SEBI will grant the application, and the stock exchange is willing to comply with any other conditions. So if the SEBI imposes any other condition, and the stock exchange is also complying with that other conditions also, so they can grant the application. And the stock which is in the interest of trade and the public interest. So the public is more interested in be recognizing this stock exchange as a recognized stock exchange. So if these three criteria are covered, then it may grant or reject. So it may grant the recognition. Okay. So while granting the recognition, what are the things that the central government will look for? So we're granting the recognition to the stock exchange. Various other factors also they can look for, like the qualification of members, the qualification of office bearers. So what background they have, what education they have, so whether they can handle uh, the activities in the stock exchange. Because whenever you are recognizing a stock exchange, it is like going into a private company to public company. Means what? You have uh, more legalities, uh, more sections to adhere to the more adherence to the rules and regulations. So likewise, we have more rules and regulations to follow. So the representation of central government on each of the stock exchanges, the maintenance of accounts of members. So you have the rules like auditing the uh, audit requirements. Okay, so the rotation of data. So many rules which can be imposed whenever you are recognizing as a stock exchange. Okay, so after the grant of recognition that is made by the central government, they have to publish in the official gazette for the purpose of publishing this gazette, uh, for what for the general public to know that this stock exchange has been recognized as a recognized stock exchange. So for the purpose of this, they have to publish in the official gazette. If no application shall be refused after, this is the main important thing. They have to give an opportunity of being heard whenever they are rejecting. Whenever there is a refusal, they have to give an opportunity of being heard to the concerned stock exchange. Okay, that is all about your grant of recognized stock exchange. Okay, next one is your withdrawal. After being recognized, the stock exchange is being withdrawn from the recognition. So the section 5. So here it is section 4. Here it is section 5. That is your withdrawal of recognition. That is of the opinion that the recognition granted to the stock exchange should in the interest of paid. This is what we have seen earlier in the section 4. It should be in the interest of the trade and in the public interest, right? So here also they are saying it should be in the interest of the trade or in the public interest. And so for the purpose of recognition also, it should be in the public interest. And whenever the public feels that this stock exchange has to be withdrawn from the recognition, then the central government, after considering various other factors, may give a written notice before such withdrawal, and they may withdraw from the recognition. Okay, so yeah, whenever the stock exchange is being withdrawn, what has happened to your contract which has been which has been created before such withdrawal? So here they are clearly stating that there is no effect. So it should be valid even after the withdrawal of recognition, maybe before date. So there is no effect on the validity of any contract. Uh, okay. So here they say where the recognized stock exchange has been corporatized or demutualized, has not been. So uh, even now there may be some possibilities that it is not possible, but if it is possible, if there is any stock exchange that has not been corporatized or not been demutualized, then the central government may reject, because every stock exchange now has to be corporatized and demutualized. So it should be in a corporate form. That is your like NSE Limited and DSE Limited. They has to be in the corporate form and not in the broker form. So recognition, if the recognition has already been granted, means it has to be rejected. So the central government, after giving it a notice, they will withdraw the recognition. Okay. Even here also stating the validity of the contract will not affect by withdrawing the recognition. Okay. So all the powers are given to the SEBI. The SEBI will take care of all these things. Okay, this is the main important sections. So that is your recognition of stock exchange in your section 3 and 4 and 5. Section 3 is your application, 4 is your grant, 5 is your withdrawal. Okay, and next topic is your powers conferred under SCRA Act. So who are all have the powers in under the SCR Act? The central government has the power. The central government has delegated the powers to the SEBI. The central government has the powers. The powers of SEBI. What are the powers do the SEBI have? And what are the powers of the stock exchange to make bylaws, to make rules? Okay, so let's see. First, we cover the section 6, which is your powers of the central government shall furnish to the SEBI. This is your section 6, powers of the central government. Here, what are they telling? That if you are being granted as a recognized stock exchange, you will be happy. So you will have a happy face. So, but after that, they are telling if you are being recognized as a stock exchange, they will impose more rules and regulations to follow. So, what are the rules? What are the powers of the central government to make you follow the rules? So, every recognized stock exchange has to give a periodical returns, has to give periodical returns to their affairs, to their affairs of the company. What are the things that has been taken place? What are the transactions which has to be periodically filed to the SEBI? So the SEBI knows, oh, what are this transaction has taken place. Okay, and here the preservation of books and accounts. So on how many years I have to, as a stock exchange, preserve these books of accounts? Generally, it is for 5 years. Preserve for not exceeding 5 years. For a minimum period, they have to preserve these books of documents for a period of 5 years. But whenever there is a dispute or whenever there is a case that has been going on regarding these preservation, then they have to preserve it for till the dispute gets over. Okay, so generally it's 5 years. Okay, so powers of SEBI in public interest also, they can call upon any recognized stock exchange to give to give these books of accounts or any other documents, or they can call any members. They can call any members, or they can appoint any members as an investigating authority to make such inquiries. They can call upon recognized stock exchange. They can appoint an authority to make such inquiry. Okay, and they will submit a report, which is your final report. This is like your CBI. They will appoint a investigating authority, and they will submit a report based on the inquiry. So the stock exchanges are bound to produce. So after what if the stock exchange members not follow the not follow the commands that has been given by the investigative authority? So the act clearly states that the stock exchanges is bound to produce the documents. Stock exchange is bound to produce documents. Every director, every manager, every secretary, every member of such stock exchanges, every person who has been connected has to mandatorily produce such documents before the authority. Okay, so section 6 talks about your periodical returns and what are the powers do the stock exchanges, do the SEBI have, and stock exchange has to bound to produce the documents. Okay, so section 8 here. So section cover comes in the later part. So let's see the section 8 part, which is here to direct rules or make rules. So central government has the power to make itself rules, or to direct rules, or to amend the rules, or to change the rules. Okay, section 8 gives the central government to make rules. Central government has the power to make rules, or to change the rules, or to direct the rules to the stock exchange. Okay, after consulting with every stock exchanges, that is to the especially to the generally to one stock exchange, or it can be in a overall, it can be in a general basis. Okay, in a particular basis, or it can be in a general basis. Okay, so any make any rules or amend means any changing any rules that has been already made. Okay, if any of them neglects, if any of the stock exchange fails or neglects to follow such rules. Okay, they will they will make the rules for amend the rules. The central government mandatorily amend their rules. Okay, so after amendment, it has to be published in the official gazette. So then only the general public or everyone knows that the rules has been amended. So by looking in the official gazette, so the stock exchange knows, or the general public knows, that it has been amended. So they will be aware of the new rules and regulations. Okay, so yeah, let's see your section 11. Section 11, the superseding governing bodies of recognized stock exchange. So this is the section where, if the recognized stock, so generally the recognized stock exchange office bearers or any of the persons have the powers, right? So what if they are misusing their powers? What if the central government knows that these stock exchange members are misusing their powers? So the central government, uh, after considering various factors, they will supersede, that the central government itself uh, take care of those stock exchange, and all the members which are in the stock exchange will cease to exist. So if the powers of them would cease to exist, and the central government would appoint any authority, and the appointing authority would take care of all the matters connected with the stock exchanges without prejudice, that is, without harming to any powers which has been vested in the central government. So central government is of the opinion that central government is satisfied that some misuse of power, something which is not regular is being happening on the stock exchange, then the central government should be superseded, and by giving a written notice to the concerned stock exchange, it may supersede, and may appoint any persons for the purpose of the supersession, for the purpose of, the stock exchange would hold various properties now. So the properties has to be held in any person's name. So for the purpose of this, the central government may appoint any person for the purpose of holding the uh, properties that has been held by the stock exchange on the publication. So uh, after satisfied by the central government, it has to be notified in the official gazette. So what are the consequences after publication in the official gazette? The members of the governing body. So the members of the governing body means members of the stock exchange will be ceased to hold the office. All the powers will lose. All the powers will go to the central government, and the person appointed may exercise the power. The person appointed will hold the property, will hold the powers and duties. Okay, so all such properties which has to be transferred to the appointing authority, appointing person. Okay, and such and such period to such and such period, they will hold this stock exchange. Okay, so okay, finish. So next one is your section 12. Section 12 is your suspend the business. So supersession before supersession is your ultimate, that is your major last part. So before that, it can also be suspended for a temporary period. Generally it is for 7 days. We have not exceeding 7 days. Yeah. So generally, the central government can uh, suspend any stock exchange for a period of not exceeding 7 days for the purpose of any meeting emergency. So if example, if the corona spread, so we have to suspend every stock exchange. We have to suspend any either the particular stock exchange or the general stock exchange. For example, if you have to suspend which, so the central government has the power to suspend the stock exchange for a period of not exceeding 7 days. It can also exceed 7 days if it is in the interest of trade or the public. If the public interest then it can exceed 7 days also. So for the purpose of this, no notification extending shall be issued. So issued unless they have given the opportunity. So opportunity being heard has to be given if they are extending the period of 7 days. So without this, no notification has to be given. But if you are extending the period of 7 days, after giving opportunity of being heard, after notifying official gazette, you can suspend this stock exchanges from transacting into the business activities. Okay. And your section 16. Section 16 talks about prohibit contracts. So section 12 talks about your entire stock exchange. But here they specifically into the contracts. So specific contracts like equity or debentures or bonds, specifically they are, prohibiting because of any emergency, or if there is any irregularities in some specific state or specific country, they can prohibit any transaction. So let's say, for example, we have the central government is satisfied. The central government is prohibiting any contracts, prohibiting any transactions from nearing countries like Pakistan, Bangladesh. So likewise, they can prohibit also any undesirable speculation which is happening in a particular state or any area, so which can be notified in the official gazette. So no person in the state, this is to the state that is within India, they can prohibit any contract for the purpose of this preventing any undesirable transaction. Okay. And to grant immunity, so section 23O, to grant immunity. Grant immunity means what? If there is any case that has been started against you, or any case, or that other person has done something wrong, so you can convey it to the central government. And if you both are doing something wrong, but you itself has come forwarded and you stated that yes, I had done something wrong, and this other person has also doing wrong, or has already done wrong, or has the probability of doing wrong in the near future, with the adequate proof, if such person is conveying such important information, means the central government can grant immunity, that is your police force, that is your protection to them, and can reduce their legal action, reduce the legal action of such person who is conveying such information. So to grant immunity means, so on recommendation, that any person who is alleged to have violated, so such person, such information conveying person has violated some rules, he himself has violated some rules, any of the provisions of the rules, has made a full and true disclosure that yes, I'm sorry that I had violated this rules, this regulations. Grant to such person, they enforce immunity from prosecution for any offense under this act, so they can grant immunity. Okay. Yeah. So, but this immunity shall not be granted when already the prosecution has been initiated, because the central government has taken some efforts to identify who are all the persons are not following the rules and regulations, and initiated a prosecution against a person. And after this, that person is coming to the central government that, oh, sorry, I'm sorry, I had not followed the rules, means, so no, no immunity shall be granted, because central government has made some effort to identify these prosecutions, right? The proceedings has already been initiated before the date of receipt of application for grant of such immunity. Okay. And may withdrawn, say any, so if the immunity has been granted to any person, and after sometimes the central government has got the information that the information that has been conveyed by such person is wrong, or it is to distract the other thing, other illegality, so then it may withdraw the uh, immunity that has been granted by the central government. So any false informations, okay, or tried for the offense with respect to which immunity was granted, after getting the immunity, so you're gaining the immunity for the purpose of doing the offense itself, so it shall be withdrawn. Okay, that is your grant of immunity. And next one is your to delegate or to make rules. That is your section 29A and 30, powers to delegate. So the central government has to power to delegate their powers to their subordinate bodies, because the central government itself cannot do all those things, right? So the central government shall delegate its powers to other bodies like SEBI. Okay. Okay, exercisable under Act relation to such bodies, and the delegation has to be notified in the has to be published in the official gazette. Okay, and the central government itself can make the rules. All the delegated bodies can make itself the rules. Okay, make rules for the purpose of carrying to effect the objects of this act. Central government has the power to make any rules, in particular to the application, in particular to the manner of inquiry, on how the inquiry process has to be done, how effective it should be. Okay, any periodical written rules and regulations, what are the documents to be maintained. Okay, so you can take somewhere around 5 to 6 points. So in manner of appeal, so that is your SEBI to SAT, SAT to Supreme Court. So the manner of appeal and what are the in what period you have to make an appeal. Okay, and any other matters connected there with the central government has the power to make the rules and regulations. Okay, this is all about your powers of the central government. Now, what are the powers do the recognized stock exchange have? Do the recognized stock exchange have? Okay, so they have two powers. Either they have two powers, that is to make their rules, which is restricting voting rights, and to make their bylaws. That is a section 7A and section 9. Okay, section 7A. To make rules restricting voting rights means what? If any person who is holding majority of the rights in a particular stock exchange. Okay, so the person himself is having 80 percentage of shares in the recognized stock exchange. So he himself can take the majority decisions, because the uh, resolution, that is a special resolution, is itself as a 75 percentage. So he himself. So likewise, if any decision, so special resolution is between the public, but if he himself is having majority, then the recognized stock exchange shall impose any restricting voting rights that has been given to the restrict the voting rights, because whenever a person is having majority of the stake, he himself can take majority decisions. To avoid this, they can restrict the voting rights. That a recognized stock exchange may make rules or amend any rules. They can change the rules for the purpose of this restriction of voting rights to any members, regulation of voting rights. Okay, so entities to have one vote only, irrespective how many shares you can hold, irrespective of your shareholding, even if you're holding shares of 100% or 80% or 90%, you will be entitled to only have one vote, one person, one vote. Okay, so likewise, they can make restrictions to appoint any persons or to expulsion or to admit any person as an proxy. Such any powers consequential supplementary matters connected therewith. Okay, and this is powers are concurrently delegated to the SEBI. Okay, so to make any so that is all about your section 7. That is the stock exchange itself can make any restrictions on their voting rights. Okay, and now is your to make bylaws. That is your section 9 talks about the recognized stock exchange can itself make their own bylaws, make their own. That is like your opening and closing of markets. That is any periodical return statement timelines. Okay, so the opening closing of markets, prohibition of any fixing, altering, or postponing of days. So settlement cycles, that is your T+1, T+2, T+0 settlement cycles. Okay, any market rates, including opening, closing, highest. So the markets you have in the chart pattern and the market securities, you have opening, closing, and high and low rate on particular candle. If you look at a candle chart in your any app demat in any app. Example, your trading view. In trading view, if you see any particular chart for the particular securities, you will have a candlestick pattern. So each candlestick pattern represents the market uh, rate, market price of the securities. You will have a candlestick. So you have opening and your closing and what is the highest price which the candle has gone, and what is the lowest price which the candle has gone. So it would have four prices. So it can be, the various rules of which is concerned with the opening, closing, highest, lowest, can be done by the recognized stock exchange. Okay, so any separation of functions between your brokers. So the powers can be uh, delegated to other parties also. So likewise, yeah. And so that is the two main powers of the recognized stock exchange. One is to restricting the voting rights, and another one is to make your own bylaws. And the powers of the SEBI. What are the powers do the SEBI itself has means? So SEBI also has the powers to make rules or make bylaws. According to Section 10, they can make rules same as the central government. They can amend. They have to publish in the official gazette. Okay, same as your earlier part, and they can issue directions. Section 12A says this, they can issue directions. They can direct the stock exchange to do these things if the public is involved. If the public is interest of investor is stating that you have to direct the stock exchange to do these rules, okay, to prevent any undesirable transactions, okay, or to secure the proper management, they can issue directions to any stock exchange or to particular company or particular securities, okay, to make regulations same like, they have the powers to make, you know uh, make any regulation which has to be published in the official gazette, same rules and conditions. Okay, the SEBI has further regulations, which is, one is your insider trading. In this regulation talks about to prevent any insider trading. Any insider member is having the uh, unpublished price sensitive information. The person have UPSI. So with that information they can trade. No, so to maintain an equality among the investors, this regulation has been enacted. And LODR, whenever the security has been listed on the stock exchange, every company has to follow, every security has to follow the SEBI LODR. Issue of capital and disclosure requirement. Every company which is in the process of listing its securities in the stock exchange has to mandatorily follow this issue of capital disclosure. SAST, substantial acquisition. Whenever there's a takeover, whenever there's a merger, amalgamation, this regulation will take place. Whenever there's a buyback of securities by a company for any purpose, whenever you're delisting your equity shares from the recognized stock exchange, either it can be voluntary or it can be compulsory. So you have to follow this is regulations. Okay. And to adjudicate, section 23I talks about your adjudicating, that is to, you know SEBI sat, yeah, powers to adjudicate. SEBI itself can adjudicate, like a court itself can adjudicate. They appoint any officer for the purpose of this adjudication, and they have to give a reasonable opportunity of being heard. They can make an inquiry, they can make a report, make a call for any information, they can examine the records, they can mark any they can that mark any markings in the documents. Okay, so okay, so SEBI itself can act as an adjudicating authority. Okay, next, this is important, means the powers of SEBI not to apply IFSC, that is your International Financial Service Center. International Financial Service Center, uh, it has an SEZ, so Special Economic Zone. So Special Economic Zone Act, Special Economic Zone is an place where for the purpose of taxation, for the purpose of rules and regulations, it is considered as an another country. It is not a country of India. It is considered as another country, or it is considered as a foreign territory. It is considered as a foreign territory. So all the taxation rules, all the powers, all the rules and regulations that is in the respective country would not apply to the IFSC zone, which is completely different from our territory. Okay, so so the rules and regulations which are for the IFSC is dealt in IFSC Act. 2019, all the rules and regulations that has been in the IFSC Act would apply for the IFSC zone, and the normal rules and regulations. So they have their separate authority, they have their separate rules, they have separate inquiry process, they have their separate adjudicating authority. Okay, it is all separate from your territory. In India, we have currently your gift city in your Gujarat, gift IFSC, that is in your Gujarat. You have a special economic zone. In that zone, everything is different from the India. So IFSC in special economic zone, why we are giving those benefits, why we are giving those tax benefits means for the purpose of development. In that zone, in the zone, all the clients are from the another country. So the purpose of development, so all these things we have given this tax exemption, tax holiday period, etc. And this public issue, this not important. I don't think this can be asked in an exam. Okay, listing of securities. So whenever you are listing your securities, section 21 talks about whenever you are listing your securities, you have to mandatorily follow your uh, after listing of securities, you have to mandatorily follow your SEBI LODR regulation. But whenever you are listing or in the process of listing, you have to follow SEBI ICDR regulations. And right of appeal. So from this, it is more in general. Okay. So till now we have completed the section part. Okay, that is more general. That is your right of appeal. So whenever you're dissatisfied by the order of the SEBI, you can go to the central government. Here they're talking about whenever there's a refusal of stock exchanges to list of securities of public companies. So if I'm a company, I want to list my securities in the respective stock exchange. But what if the respective stock exchange is not allowing me to list my securities in the respective stock exchanges? So where do I go? So I have two options. Either I can go to the central government or I can go to SEBI. SAT. Either I can go to central government or to SAT. So the same points are being replicated. So within 15 days. So within 15 days. So on such refusal, if the stock exchange has refused me, I have to go to the central government within 15 days or to the SAT within 15 days. Okay. So any omitted failed to dispose. Okay. The application for permission. So the permission is not being. So the permission is not given by the stock exchange. I can go within 15 days. Okay. So the same points has been given in the SAT also within 15 days. Same permission. So omitted the permission. Okay. The same points has been given. Right of legal representation. This is where we company secretaries has been given recognition. So we company secretaries can legally represent in any legal matters. So we have CA, CS, CWA, or your legal practitioners can present their case before the SAT. In SAT, we have been given as a legal recognition, as a legal representation. We can legally represent in the SAT. And whenever a person is being dissatisfied by the order of the SAT, can appeal to Supreme Court within a period of 60 days. Whenever a person who has been dissatisfied by the order of SEBI can go to SAT within a period of 45 days, that you will see in the later part. SEBI to SAT is 45 days and SAT to Supreme Court is within 60 days. Okay. And if there is any sufficient cause, there is a doctrine of sufficient cause. If there is any sufficient cause, which may exceed 60 days also, but it should not exceed further 60 days. So max period is 120 days. And till now, everything goes smoothly and nicely. But what if any person who's not following the rules, any person who is not following the regulations, what are the consequences do such person have? Do such stock exchange or do any member have? Any person who without any reasonable excuse or any contravention of the act contravenance provision, contravention act, okay, they shall be penalized. They shall be penalized. They have given various penalties for various matters, but obviously, as a person, we cannot remember everything, right? We cannot remember everything, but I'll give you a simple hack to remember the general penalties and the other penalties also. I will give you a simple hack to remember this. What is the hack? Okay. So the main general penalty or the main general penalty is your 25 crores. Main general penalty is your 25 crores or 10 years or both. So 25 crores is your monetary penalty or 10 years imprisonment or both. This is your general penalty which you can quote whenever in the question they ask about the penalty in the SCR Act. Okay. That is your 10 years or with fine 25 crores or both. This is important. Okay. This is important. So 25 crores or 10 years or both or with fine. Okay. This is important. And but what if but if you know the exact matters means you can write. That is well and good. But if you don't remember anything about the penalty means you can write that. But I'll give you hack. That is whenever it is concerned with your books of accounts. Books and your another part. Okay. Whenever it is concerned with books of accounts, enter into agreement. Okay. Enter into agreement or books of accounts. It is your agreement as well as your client. Agreement as well as your investor grievances. That is your investor is your client, right? Investor grievances or any client. It is your 1 lakh rupees. At least 1 lakh rupees. 1 lakh per day, maximum 1 crore. Same. 1 lakh rupees, 1 lakh per day, 1 crore. Okay. The same points for whenever it is concerned with books of accounts and whenever it is concerned with the client. It is the same penalty. So 5 penalties 5 penalty whenever it is concerned with books of accounts and it is whenever it is concerned with clients, it is 1 lakh 1 lakh rupees, but 1 lakh per day, maximum 1 crore. Okay. And whenever it is others like your listing conditions, dematerialization of account, the dematerialization of delivery of unlisted securities. Whenever it is others, it is your 5 lakh rupees. Okay. So all the other part. So first one is your whenever it is concerned with books of accounts. Whenever it is concerned with books of accounts and client, it is 1 lakh rupees penalty. But if they fail, 1 lakh rupees per day, maximum to the extent of 1 crore rupees. Whenever it is other than this, it is 5 lakh rupees, which may extend to 5 crores, 25 crores, which may extend to 25 crores. Simple, na? Which this cannot be asked in your exam. Whenever there is no provisions with regarding to your penalty, which is 1 lakh rupees, this is not important. So 3 penalties. One is your general penalty, which you can quote in every answer with regarding to penalty in the SCR Act, which is your 25 crores or 10 years or both or 5. Clear? And another thing is whenever it is with the books of accounts and whenever it is with the clients, it is 1 lakh maximum to the extent of 1 crore. Whenever it is others, 5 lakh 25 crores. Easy, simple. Yes. Let's move ahead. And yeah. Next one is your section 23JA, which is your settlement of administrative and civil proceedings. Whenever a penalty has been imposed, that is your 10 years imprisonment has been imposed means you can settle those things in your monetary terms. We can settle those things in the monetary terms. So based on your allegations, based on your nature of the offense that has been done by you, so based on that, it can be settled. If any proceeding has been initiated, may file an application for the purpose of this settlement. For the purpose of this settlement, but not every proceedings can be settled. So SEBI will look the nature, gravity, impact of the faults, and it may grant or reject the application for the uh, settlement. Okay. Okay. Whenever a person is aggrieved, this is important. This is very, 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 very important. This can be asked in your exam. This can be asked in your exam. So kindly please note it down as very, very, very important. Okay. So stipulates that any person who is aggrieved, section 23L, this you have to quote with the section number. Okay. Quote with the section number. Whenever a person is being aggrieved by the order of the SEBI, they can go to the SAT within a period of 45 days. Within a period of 45 days, whenever a person is being aggrieved by the order of SAT, they can go to the Supreme Court within a period of 60 days. Within a period of 60 days, and all the cases has to be disposed in the SAT within a period of 6 months. Within a period of 6 months. Okay. Within a period of 6 months from the date of receipt of such appeal. Okay. So I may entertain an appeal after the expiry period. Also, this is a doctrine of sufficient cause. Okay, this is all about. So this is your major points. Whenever a person is aggrieved, they can go to SAT within a period of 45 days, and SAT give the opportunity of being heard, and a copy will be sent to the concerned parties, and all the cases has to be disposed within a period of 6 months from the date of such receipt of appeal. Okay. Yeah. Okay. So offenses. Offenses and penalties, like if any person has any contravened any rules or regulations in the bylaws, they are also having an imprisonment of 10 years or with fine, which may extend to 25 crores. This is same as your penalty, right? So if they ask about your penalty or the offense, you can write the general stuff, that is your 25 crores or 10 years imprisonment or both. Okay. And till now, we have completed the SCRA Act 1956. From now, we are going to cover SCRR rules 1957. Your rules is your 1957 and your act is your 1956. So there are many rules in which we have in this chapter, but not all the rules are important. I will say whichever rules is important in the from the point of your examination. Okay. So what is the objective? So the main objective of the act means to prevent any undesirable transaction, to protect the investors. Okay, right. To regulate the business entities who are dealing in the purchase and sale of securities. Okay, that is your objective of the act. But what is the objective of the rules? The rules means any procedures. So the procedures to be followed by the recognized stock exchange. What are the procedures regarding your periodical returns? What are the inquiry matters? What is the requirements? That is eligibility. So, what are the requirements to get listed to be on the stock exchange? What are the requirements listing on securities? If you want to list the securities on the stock exchange, what are the requirements that the specific securities has to? So that and all we cover in the SCRR rules 1957. Okay, so this is the main important provision because they themselves has quoted this is the main important provisions of SCRR rules, right? So which talks about your documents, which talks about what are the things which you require, for the purpose of procedure. These are getting is the securities listed on stock exchange. If I want to list my securities on the recognized stock exchange, what are the things that I should accompany with? Your memorandum, your MOA, AOA, or prospectus, or offer for sale documents. This is generally your balance sheet. This is generally the documents which regard to the securities and which regard to your company. And dividends, details, any vendor, any underwriters which you are appointing for the purpose of listing, any brokers, sub brokers, etc. Okay. And rule 2 is not that important because it is stating that any other terms. So other than rule 19.1, if any other rules also, it should have any other rules, any other conditions, any other documents. So the articles. So in rule 19.1, they have stated that you should have article. But rule 19.2 stating that your article should allow you to get listed on the stock exchange. Company is a common form of transfer because it should not be so complex like a physical transaction. So it should be easily, which is in line with other securities, and it should be fully paid up shares. No partly paid is allowed. Okay, any paid in advance, they carry interest. Okay, no forfeiture. Okay, this is generally the other terms and conditions, which is other than the 19.1. Okay, and 2b is not important because it is not important, and 19.2b and condition present submission is also not important because it cannot be asked in the exam. This is generally your other conditions. You can make a one time reading to get an understanding. Okay, application for listing. So you have to make an application in section 3. We talk about recognition of stock exchange. So whenever stock exchange has to be recognized means they have to make an application. Likewise, if you're going to list your securities, you also have to make an application for the purpose of listing your securities on the recognized stock exchange. All new issues has to be make an application. All further issues, if you're further issuing your shares for the purpose of raising funds, you can also make. You have to make an application. And after granting the after granting the request, they can also suspend. They can also remove. Okay, which is simple. They can also suspend by giving a written notice. Okay, by giving reasonable opportunity being heard in the written notice, and any person aggrieved can go to SAT, and further they can go to Supreme Court. Okay, and Rule 19A. Rule 19A is your most important rule. Most important rule. Mark it as super, 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 super important. Okay, because this can be asked in your exam. Okay, so Rule 19A. Rule 19A stipulates that it talks about your minimum shareholding. It talks about your minimum shareholding in the company. Whenever a security is being listed on the stock exchanges, so in a company it should be minimum 25% should the public should be involved. The minimum public shareholding should not reduce below the 25%. But if the minimum public shareholding is 25% means what is the maximum shareholding that the promoter should have? Promoter shall have. The maximum they can have is 75%. But what if the promoter is having 76%? Then ultimately their minimum public shareholding reduces to 24%. So such 24% has to be increased to 25% within a period of 1 year. Within a period of, that is your 12 months, they have to increase this 24% to 25%. What if they are not doing? They will be penalized, they will be removed from the stock exchange, and all the consequences they have to face. Okay, let's see that every public company has to have a minimum public shareholding of 25%. If it falls below 25%, it should be increased within a period of 1 year. But here they're telling us 3 years, which is from the date of such commencement. Date of such the act commencing. So if the act is commencing on today, they have given a period of 3 years because now only it got commenced. So before that, nobody knows it. So they're giving period of 3 years. But now it is irrelevant. Now what is relevant is if anything which falls below, this is important. If anything which falls below 25% shall bring the public shareholding to 25% within a maximum period of 12 months. They have given you 12 months to increase your public shareholding to 25%. 25% they have given for various companies, like your public sector companies, like your normal companies. They have given various various years. Within here they have given for public sector company, they have given 2 years. For public company, they have given 1 year. For commencement, they have given 3 years. but you can generally remember this is the most important. Sub-rule 2 is the most important. Whenever a company's public shareholding is falling below 25%, they have to increase it to 25% within a period of 12 months. Okay, and yeah, that is all about your minimum public shareholding. So with this, I had completed the entire chapter of ACRA Act 1956 with in-depth and your important concept as well. Thank you.